Hello everyone, and welcome to today's webcast entitled 5 Steps to Building Your Data Governance Plan. I'd like to start off by introducing our two presenters today. We have Malti Miraj, who's the Senior Counsel here at Tealium, as well as Chris Slovak, who's VP of Solutions Consulting. Today's webinar focuses on a really important aspect of data management inside of today's organization, and we look forward to your questions throughout the presentation today, and we'll make sure to save some time at the end of the webcast to address any questions, but those that we don't get to, we'll make sure to follow up with one-on-one after the webcast concludes. If you do have questions throughout the webinar today, please feel free to type them into the webcast window. There's a questions button right at the top of the screen, so you can go ahead and click on that at any point throughout the presentation, and it will not interrupt your viewing of any of the content. With that, I would love to go ahead and turn it over to Chris Slovak.
All right, thanks, Adam. Thanks, everybody, for joining us here today. Before we start talking about what to do, we wanted to talk a little bit about how we ended up where we're at. Today, I'm going to go through a little bit of the sort of industry history, and then Malti is going to go through some legal landscape considerations that you need to consider as we get into the 5 steps to start to build out your plan. So with that, I think everyone really knows this. There has just been this massive proliferation of vendors out in the space, up to 3,800 plus different MarTech vendors out in the space today. And many of them are really helping to build niche channel experiences for our customers, right? Drive value out of campaigns. And in many cases, they're needed. And in fact, so much so that we're seeing that on average, 21 or more vendors are used by teams. In fact, this is some data that we did with eConsultancy between 2012 and 2015, where you're actually starting to see that ramp up into a higher number in 2016. But sometimes it feels like as a business team, you're kind of lost in the mix, right? Lost in the shuffle of all of these vendors who have competing technologies, competing architectures, competing service provisions, but also you have to really start to consider the challenges that having this many vendors bring up, not only around your data and the coordination of your data, but also just internally, right? And we see these common challenges both on the business side and the technology side, both from an experience all the way down to an intelligence or warehousing level, right? The business team, they want more control. They need things to be done faster. They don't have centralized data sets. The data is inconsistent when they do get it back. They don't have access to it. They can't activate on it. And on the technology side, technology teams are really concerned with governance. They're concerned with performance. There's too much effort. There's inconsistent data leakage. They're worried about one-off integrations. And it's this proliferation met with this unfortunate limit on how fast we can get things to market and how clean we can get them to market in a decentralized world that leads to a lot of these data issues that we're seeing today. And let's talk a little bit about that, right? Let's talk a little bit about this whole idea about privacy, because privacy is thrown around a lot. Governance is thrown around a lot, but really what it comes down to, at least in our view, is this idea of customer trust. And customer trust is really fragile. Think about your customers, right? When they come and they engage with your brand, they have faith in your brand. They have an experience that's personal with your brand, and that in many cases from a privacy perspective is that they consider, right, the policies that you put in place that you're going to protect them. And sometimes it's really obvious on the surface as business people and marketers that, hey, we're going to add a bunch of tags, we're going to add a bunch of code, we're going to collect a bunch of data into these vendors so that I can provide these channel experiences. But unfortunately, it becomes a little bit more difficult to predict what actually happens with your customers' data once it gets into these vendors. Where is this stored? What are they storing? Why are they storing it? What are they using it for? And what's worse, this becomes much more scary when you start to think about the implications from a global perspective. A global perspective from both where is the data actually being stored? Offshore, is it onshore? Is it being stored in global instances that are replicated? And what's kind of getting more and more scary is the fact that this becomes risky business, right? As a great example of this, the German laws are very, very, very specific around the use, the storage, and the access to their citizens' data sets, right? So, this proliferation meeting business challenge, technical challenge meets a concern around data trust and privacy, but moreover, it leads to legal risk, right? And we're starting to see that the space as a whole is leading up to massive change, and I kind of call it at the brink, right? And let's talk a little bit about that, right? Customers are demanding better cross-channel experiences, but they're also demanding more from their brands. They're installing web blockers, or they're using web browsers that block third-party cookies. There's advocacy groups that are constantly sort of just looking for policies that are out of compliance. Providers themselves are starting to protect their gardens more and more. I think Apple has been doing this for the last 5 years, putting in restrictions on Safari's third-party cookie usage. They've really ratcheted down the use of IDFA. Google has really made some big changes around access to third-party pixels on owned and operated sites. At the same time, they've really started to embrace first-party data sets by enabling things like customer match. We've seen that with Facebook as well and their custom audiences. And then governments are getting involved, right? They're starting to require this privacy, and we're starting to see things like the Turn Verizon ruling, the dissolving of Safe Harbor, and the advent of Privacy Shield and GDPR, and of course, even the FTC has had some panels and some notices on this, which Malti's going to go to in detail in a minute. And then, if that's not enough, we're all feeling it internally, right? I'm sure any of you that have purchased solutions or tried to get new vendors installed have gone through lengthy infosec processes. The technology teams within these organizations, and rightfully so, they're very concerned about who has access to their data. They're getting into conversations around not letting piggyback pixels, disallowing custom code, disallowing third-party cookies. So we're at the brink, right? These precursors to massive change in our space, not only because we need to do it for our customers, but we need to do it for the governments, and frankly, we should do it because of ethical reasons. They're here, right? And I think what we're going to start to see in the legal landscape, which is what I'm going to turn over to Malti to talk a little bit about, is that these regulations are starting to come forth, and we'll see some massive change here soon. So, Malti.
Thanks, Chris. So I'm doing this presentation regarding the legal landscape, but sort of narrowing it only to the U.S., to data transfers between the U.S. and the EU, and also what's happening in the EU. But I want you to keep in mind that there's a lot more going on in the world, whether it's in the APAC region. You have regulations coming out of China, regulations coming out of Russia, and a lot of things happening in the Latin American market. But I'm just going to focus on the U.S. and the EU for this particular presentation. So one of the things I think that people struggle with is, what exactly is happening in the U.S. with respect to privacy. We don't have a comprehensive national privacy law, but we do have significant regulations, especially in particular industries, like the health industry, the financial sector, very, very heavily regulated. And on top of that, we have all of the states having a diverse number of privacy and security requirements from a regulatory perspective. Some of them at the top of the list would be California and Massachusetts. So we are playing in an environment in the U.S. in which we have both national laws at a higher level on a sectorial point of view, and then we have state laws, all of which you have to sort of keep in mind when you are looking at what sort of privacy and security goals you need to consider. So in the U.S., from a national point of view, the FTC is one of our major players. And to be sure, the FTC is looking at defining what personally identifiable information is. And it's sort of becoming quite the norm that not only things that we're accustomed to, like names and addresses and government-issued ID numbers, but they're also looking at identifiers like IP addresses and device identifiers of various kinds as falling under the entire jurisdiction of what is personally identifiable information. So we'll talk a little bit now about what's happening as between the US and the EU in terms of data transfer. So for a long time, we had the Privacy Shield in effect, and the Safe Harbor, in effect. And the reason for Safe Harbor is that under the EU Directive 95/46/EC, the only way you could transfer personal data from outside the EU to another country, to a third country, was if that country had a finding of adequacy. Well, the European Parliament found that the U.S. had no finding of adequacy, and so the safe harbor was put in place to permit that transfer of information in between the two entities. In October of 2025, the EU Court of Justice invalidated safe harbor. For a long time, we were without any valid framework for transferring of data. But beginning in July of this year, the Privacy Shield framework was put into place. Now, if you go to the Department of Commerce website and you look at the Privacy Shield list, you're going to find that it's still not heavily populated, not the way Safe Harbor was, and I think it's because a lot of people are still trying to figure out whether Privacy Shield is appropriate for them, and if it's not, what's a valid mechanism under to which transfer data between the EU and the US. Now, the requirements of Privacy Shield is substantially similar to what we had under the Safe Harbor framework, but it's like Safe Harbor pretty much on steroids. And so you've got all of the things that you had before. You have notice, you have choice, you have accountability for onward transfer, security, and data access. But on top of that, you have things like how do you do alternative dispute resolution at no cost to an EU citizen, and you have the recourse and liability being much further enhanced than you had before. And so what you need to consider when you're looking at how to transfer data between the U.S. and the European Union, you need to think about whether Privacy Shield in fact works for you, and also to keep in mind that some of the other mechanisms of transfer are also being questioned. So, for example, you have things like you have Schrems, Max Schrems from the original decision that overturned Safe Harbor, bringing a challenge about the standard contractual clauses. And so, you still have to consider, well, if you are using standard contractual clauses as a valid mechanism, how long will it be valid, and whether, in fact, it would be worth the while embracing the Privacy Shield. So the other big thing that's happening in Europe right now is the General Data Protection Regulations. And so the original 1995 directive was found to be inadequate, naturally, of course, because so much has changed between then in terms of technology, in terms of how we use data, in terms of the amount of data that's being provided. And so the GDPR is basically going to be in place, and it's not going to affect only people who are in Europe. It's going to affect any of us who happen to be providing goods and services to EU citizens. And for those of us in the internet world, that's a de facto case. And so as long as you're providing goods and services, even if those are free to EU citizens, and if EU data subjects' behavior is being monitored, then the GDPR applies to you. Now, one of the things that's going to be a big thing that companies are going to have to consider is the enhanced right of data subjects under the new regulations. And basically, one of the big things is the right to be forgotten. If a data subject comes to you and say, I want all of my data erased, I want you to keep nothing, then that right to be forgotten has to be honored. And also, if that data subject says, I need my data to be transferred to another entity, then that also has to be honored. So those are the two big things, that you have to keep in mind. We're also going to be enhanced requirements regarding policies and safeguards. And one of the big thing about the safeguards that is going to be important for us as companies doing business in Europe is the establishment of a data protection officer. As long as you're an organization that gathers data as part of your core activity, or if you are processing sensitive personal data, then it becomes imperative for you to assign a data protection officer. And the data protection officer is going to act not only sort of like an interface between your company and the outside world, but the data protection officer is also going to be monitoring your company as well for compliance with privacy law. The explicit consent is fundamental to the GDPR. you can no longer rely on pre-checked boxes. You can no longer rely on people not doing anything while they're using your website. You have got to make sure that you have consent given for collecting data that is unambiguous, specific, and informed. And on top of that, which is pretty much new for the European market, you now have parental consent required for for collection of data to minors. For those of us in the U.S., we're accustomed to the COPPA regulations, which does require parental consent for minors, and minors is fairly strictly defined because it's a national law. What's happening in the EU, though, is that the member states are going to be allowed to define what a minor is. And so it might be that if you're allowed to market to minors in one state and that definition of minor might be 16 years old, in another member state it might be 13. It's totally up to the discretion of the member states, and that sort of information is still coming out, by and by. Another big change for the GDPR compared to the directive is the obligations of a data processor. So whereas before the data controller was the main entity in the spotlight, now the obligations are also going downstream to the data processor. And the data processor, in turn, has to make sure that they are, reliable in terms of sending data to sub-processors. You must make sure that if you have sub-processors, that you have the proper contractual obligations, the proper audit obligations to make sure that you are also protecting that personal data downstream. And now as well, the data processor is directly reliable for non-compliance in terms of the use or misuse of that personal data. The rights of data subject, as I said before, is going to be really enhanced. The right to be forgotten, a big thing, because now we have to make sure that whatever technology we're using to collect our data, to store data, is also capable of erasing that data and erasing it completely. And then that right of data transferability, is it possible for your data, if a data subject should ask, to be transferred to another entity? Do you have that functionality in place from a technology point of view? So that becomes very, very important, for us to think about, because you're not only thinking about, a policy that you might have or what you're putting on your privacy policy, but you're also thinking about, can my technology or can my downstream vendors' technology do what is required regarding the data subject rights? We talked a little bit about this before, but I just wanted to remind everyone that under the GDPR, you still have 4 methods of transferring data between the US and the EU. The privacy shield, for example, or going to a country that has an adequacy finding. You have binding corporate rules. You have the model clauses, which I had mentioned before is still under review by the Court of Justice in the European Union, again because of a claim brought by Max Schrems. And then you also have the binding corporate rules, and the standard contractual clause is also subject to change based on review by the working party. So those are things that you have to make sure that you keep on top of so that you know what would be a valid mechanism. It's not that the change comes quickly, but that, the change is possible. You know that it's sort of in the works. So what are the repercussions and enforcements for failure to comply with the GDPR once it comes into effect completely? Well, for minor infringement, it can be up to 10 million euros or 2% of annual worldwide turnover. And for major infringement, and the example I have on the slide is, for example, failure to obtain valid opt-in consent, would be up to 200 million euros or 4% of annual worldwide turnover. And the burden of proof lies with you, so that, if somebody brings a claim, you have to prove that you did not, in fact, infringe in any way, whether it's a minor infringement or a major infringement. And this date is something that I want everyone to keep in mind. By June 2018, so, around the same time next year, in 2 years from now, is when we have, you have enforcement beginning. So we've got a little bit of a window of a time in order to make sure that everything that needs to be done gets done. And so Chris is going to elaborate a little bit more on some of these things, but just at a high level, you can start doing the things that are necessary right now. You can start doing your data inventory. What data do you have? Where do you store it? How do you protect it? And in some cases, If you are doing high-risk processing, like you have sensitive data, then you might absolutely need to do a privacy impact assessment. Now is the time to start thinking about those things. Again, Chris is going to elaborate on some of these, but you're going to have to look at all of your policies, whether it's your privacy policies, your security policies, your procedures that you're looking at, your cookie policy in some cases. How are you getting consent? Is it opt-in consent? Do you have the technology ready so that you could honor the right to be forgotten? If you are required to appoint a DPO, do you have the mechanism in place to get that started? Because I think it is going to be a huge demand on data protection officers within the next few years, I'm sure. And so if you do want one, if you're searching for someone in-house, are you giving them the correct training for them to be appointed as a DPO? If you're searching for an external employee, you're going to be searching in a narrower market. And so those are the things I want us to keep in mind. Not forgetting, of course, that in the U.S., on top of the GDPR and on top of your proper mechanism for transferring, you also have to think about all of the federal laws that are applicable, whether you're in a healthcare industry, whether you're in a financial industry, whether you carry sensitive data, and on top of that, think about state laws as well, not just California and Massachusetts, but all state laws. You're looking at data breach notification. You're looking at requirements under those individual state laws. And so now I'm going to turn it back over to Chris, and he's going to talk about more practical steps we can take and how Tealium can help.
Awesome. Thanks, Malti. Great information for those of you that have been taking notes. We will be publishing this webinar, so you can kind of review it later on down the road. Let's talk about what we can do today. Let's talk about very specific tactical things that both the business and the technology teams can tackle. And first and foremost, to kick it off, I think that due diligence is critical. And Malti talked a little bit about this, and you'll hear me talk about it more and more as we discuss the idea of a vendor mix, but really understanding the flow of data. Where is it coming from? Who has access to it? Why are we using it? Where is it going? Where is it being stored? Building up these data inventories. What type of data is being processed? Is it actually required? What level of security does that type of data need? Is it behavioral? Is it personal? Building controls. Now, what's interesting about building controls is to make sure that you have controls both internally and externally, right? Building up policies and procedures internally, making sure that externally that you understand and you notify through terms and conditions. Number 4, build and have a data governance panel. What's the point of having controls if you don't have some activation against those internal processes, right? This is how the business and the technology teams can communicate to move the business forward. And once you've got your controls and you know that you're activating against the controls, make sure that you provide clear and accurate notice to your customers, your vendors, and the organization around the use and the specific application of the data that you collect. And if you follow these 5 procedures, you'll get into alignment with both what's happening here in the U.S., at the local and the state level, as well as getting prepared for GDPR. Of course, you always have to take into account the business and the legal ramifications of what you're doing, but these are 5 simple things that you can start to do, and let's dive into those in more tactical details from a logistical perspective. And let's start about number 1 in terms of this idea of due diligence, and I think one of the biggest things that you can do around due diligence today is to just know your vendors. Right? As a business team, identify what those vendors you use, which ones don't you use. Validate the fact that the vendor has access and what it has access to, and review your current contracts to ensure that the vendors and the contracts that you have with them are in compliance with the new regulations. As a technology team, audit your vendor technology. The vendors are going to have, I know this from being here at Tealium, many of our contracts give technology teams and our customers the ability to audit us and make sure that we're in compliance with the processes that we set forth. Do that. Right? Review those policies and make sure that they're in compliance with what your business wants as well as what the local laws are. And finally, as a technology team, as you identify non-compliant or unused vendors that the business team has helped you identify, remove them. Right? Stop enabling vendors to collect data if they're not within compliance with the laws. Now, from a practical sense, how do we achieve that? And I like to talk about this idea of the data flow, right? Because when I talk to one of those 21 vendors, what I want to understand is, what are they collecting and where are they collecting it from? How is it moving? Is it moving through tags and APIs? Is there data feeds and secure transmission or transit of the data? Where and how and why is it being processed? If the data subject has the right to opt out of automated processing, can they do it? Where is it being stored? How is it being stored? Is it being stored in a secure way? And of course, then finally, what is being stored? And then finally, from an execution perspective, a visualization perspective, an access perspective, is this data being used in the way that I expect it to be used, or is it being shared with other vendors? Whom at the other side of this data collection and this data flow has access to it? Do only I have access to it? Does the vendor themselves have access to it? Does a third party have access to it, right? So if you understand the data flow for each of the 21 vendors that you have, you and the technology team can quickly assess and ensure that you're within compliance and you've done your due diligence so that you understand as the data controller what the downstream data processes are doing with your data. Building a data inventory. This is really critical because the business needs to actually agree on the sensitivity from both a legal and an experience perspective. Some businesses are going to be a little bit more lax with their data set versus others, especially in healthcare and the financial institutions, who have to be much more rigid, right? So understanding as a business where your sensitivity is, of course, always keep in mind customer trust and ethics, but also apply legal respect to that in terms of what has considered PII in many countries. And once you understand and kind of understand the sensitivity around the data set, you can agree on what data is needed to run marketing versus operations, right? Marketing and behavioral targeting versus understanding how to communicate to your customer are very different things, right? And you should document these requirements because once you've understand and as a business decide on the sensitivity and you decide as a business what is allowed to be sort of on the front office versus the back office, if you've documented it, it's very clear for anybody who wants to deploy new technologies or use that data what they can and cannot do. Now, the technology team, they need to be responsible and enable the business to store and protect the data based on these sensitivity and these legal representations. And the technology team should further ensure that the handling is within compliance with those policies and those legal requirements. And again, technology teams, as always, should make sure that the vendors are following those rules, and the best thing that the technology team can do is check the integrations that they've built out with these vendors to ensure that it's in alignment with those business directives. Now, one thing that I always like to talk about when I think about data inventory is first and foremost is the data types that are out there. These are thrown around a lot, and I've really simplified it. This idea of first, second, and third-party data sets, right? First-party data set, you've collected it directly, you own it, you manage it, you've gotten compliance, or excuse me, you've gotten notifications to collect this data. Now, second-party data is an interesting one, right? It's kind of controlled sharing of the first-party data. It's your data, but you're sharing it selectively with others in which you've hopefully communicated both to your customer in a transparent and accurate way, as well as with either vendors or other providers. Now, third-party data is quite a bit different. That's data that's been aggregated, hopefully, and many times in an anonymous form, but then it's out and sold and given away. And once it sort of leaves your business, you more or less no longer have control over it, right? And so understanding when you work with a vendor or you work with an exchange or you work with a partner, what type of data you're talking about is super critical, because guess what? If it's going to be that back office, very highly sensitive data set, consider it first party and consider it to something that has to have the most concern and structure around it versus something that's maybe just simply behavioral, something that is inferred and doesn't necessarily track directly back to something that is your customer or could be looked at as something that's breaching trust of the customer. Maybe that's more on the third-party side of things, right? Step number 3, right? This is all about building these controls and developing policies both internally and externally, and building procedures and processes internally and externally is really critical. As business teams right? Making sure that you have contracts and you have process to work through contracts with your procurement teams. Procurement teams should be part of the decision and technology process, not just, I picked what I want and at the end I'm going to bring them in, right? The business should create governance around these processes from a usage, and they should update their internal and external communication plans. Technology teams need to make sure that they configure vendors for least access. One of the kind of simple things they can do is make sure that people only have access to the things that they need to have access to. And they can create data audit guidelines and tests that the business can actually use to make sure that they're in compliance. And of course, again, technology teams should really be focused on building these tests and auditing internally against the policies that they set forth. Oftentimes we'll talk to technology vendors who have, policies that haven't been updated in 2 years, and whether or not they've even tested or audited them is probably even more questionable. Now, none of this matters if you don't ensure that the employees are properly trained, right? It's one thing to have a policy in place that nobody takes customer data out of the office, but if you don't train your employees and they start putting stuff on flash drives and off they go, what's the point? You have to make sure that once you've developed these policies and the procedures that you're communicating internally. Now, one thing that I like to think about when building policies and procedures in particular, right, is I call it the WIFM, and it stands for what's in it for me, but really what you need to think about is the WIF-BAM, which is what's in it for the business, right? What is the service that the vendor or the technology or the channel is providing, right? What is their participation in your overall marketing program, and what features of the service are you actually using? A lot of times I talk to customers, they have these massive products and they use less than 20% of it, but they're sending 100% of the data that the vendor asks them to send. Now, think about the data that's critical for the service and the part of the service that you're using, and take that least access approach, right? Only give them the data that they need and only give them access, and both internally and externally give them access to the data sets or the solutions that are required, right, for your marketing program. And always consider what's in it for the customer. How does this impact your customers? If your customer showed up tomorrow and asked you why you use this vendor, why you use this service, how would you explain it to them? How would you explain it to them in a way that they would feel that you're doing them a service, that you're making the experience that they have with you as a brand better? Because ultimately that's what they care about, right? They don't want to hear that you're just collecting data on them because they want you to tell them that you're providing better brand experiences, you're creating data sets so that you can build better products, that you can have better timely responses to them, right? Those are valuable things for the customer, and that's always something that we have to remember because, again, trust is fragile. Now, we've got our policies in place, we've got our general data plans in place. How do we work across the organization to create a data panel so that we can communicate as a business to the technology team what we need to drive both the marketing and the customer experiences forward, make sure that we're communicating legal ramifications of non-compliance, and of course, what are the expectations that the business has on the technology team? And vice versa, the technology team needs to communicate back to the business. Right? Not only is the technology team helping to enable the business, but they're making sure that the business has best practices understanding around the transmission and storage of data, right? The technology behind all of this. They're protecting the data themselves, from both bad players, internal, external, or even the partners, right? And they're enabling the business, but of course within reason from a technology perspective, a timing perspective, and a legal perspective. So I call this process the collection directive. And it's something that can be put together, and this is just an example that I put together, and you should build your own, but feel free to use this as a structure. But as a data panel, a cross-organizational group of people, technology, legal, marketing, maybe business leadership, right? Decide how you can build a directive around data and vendors and access. And let's talk a little bit about this on the right-hand side. At the top here, we think about data accessibility, and this is really where the legal team is super important, right? They're making sure that the access to the data is reasonable from a legal perspective. On the left side, the technology team is thinking about control. How much control they're willing to give the business, give the vendors, give the end customers based on the sensitivity of the data as previously decided. And of course, the marketing team and the business team has to consider the business impact, and they need to be part of this story. Too often do I see legal has shackles on the entire business because they're so worried about being sued, or IT has shackles on the business because they're so worried about control, and then everyone wonders why the business hasn't, grown by 50% quarter over quarter. You can't shackle the marketing team, you can't shackle the sales teams to go execute because their goal is to generate revenue for the business, which is a good thing for everybody, right? And within this directive, if you use these as your sort of framework, you'll start to think about tiers. And you'll see my tiers might be at the top level, trusted vendors that have access to client-side data in real time, and they can have access to whatever data they want. Kind of scrolling all the way down to the bottom there, right? These are the ones that have low business impact. They have a high level of control and maybe a low level of data accessibility from a legal perspective. These are your back office tools, right? Maybe it's where we have untrusted vendors or non-critical data sets and data marketing activities. We decide to do things in batch and in delayed so that we can scrub the data and scrub the access to it, right? So if you have this panel, you have these good but competing sort of directives. You can build in tiers where the business can quickly identify what's the data, what's the vendor, what's the marketing activity, what type of directive does it fit in, and then apply those business processes, apply that data sensitivity, apply that level of integration relevant to the marketing program, the vendor, or the data in question. All right. Now, we've got our policies. We know what's going on. We've done our due diligence. We've looked at our data set. We know what data we have. We've built our policies and our processes around it. We've got a team that's making sure that we're activating against it with a framework. Now we need to provide clear and accurate notice to both our customers, and we should do that internally as well. We need to communicate. The business needs to make sure that they update their privacy policies, needs to make sure that specifically we talk about, the use of cookies and our IP usage or PII. They need to make sure that they provide means of opt-out. They need to make sure that they communicate with the technology on their evolving use of data. That's really important because if you go through this exercise and you don't do anything and you don't have a communication about it, 6 months from now, things change, right? The technology team needs to enable the business by providing those customers with tools to explicitly opt in, explicitly opt out. They need to ensure that the right to be forgotten and general data deletion directives are withheld, right? You don't need to store data or credit card data as in a great example of this for 3 years. If the customer is no longer a customer, they've canceled the subscription, you should forget about them. And the technology team needs to continue to communicate back to the business within reason, vendors that are maybe in compliance, that have compliance changes, or maybe they're having issues, so that the business can work with the technology teams that they're on their vendor side, right, to solve these problems, right? This is a partnership, and it has to be two-way. Now, a couple great examples of this, right, is ensuring this idea of opt-in, and of course I'm going to call out one of Tealium's customers, Volvo. This is Volvo out of Netherlands, right, where they are clearly in the language notifying the customer that they need to be opted in. And again, here in the U.S., another Tealium customer, of course, healthcare.gov. This is a great example of communicating the usage of the data set, right? This is not only giving the customers visibility into the usage of the data and in this case, the category that they're using and what they're doing with the data set that they collect, but more importantly, it also gives them the ability to opt out and do it selectively. That's just a couple of really good examples. And at the end of the day, this idea of data governance, right, is everybody's responsibility. This is not a business task. This is not an IT task, right? Business is going to drive IT, and IT is going to enable business. We have to work together, right, to tackle the future of the data space, which is evolving and has some major precursors to change. If we do it as a team and we follow these, 5 simple steps, we'll be in a great place. Now, no webinar is complete without a little blurb about why Tealium and what we're doing over here. Of course, I've already talked about Volvo and healthcare as a couple of great examples. But here at Tealium, one thing that we really believe in is the idea of standardization or consolidation and centralization of the data layer. Now, this is something that you can do without Tealium, and it's something that really, I think, as you consider your vendors, you consider your data inventory and your data directives, if you have a data layer, you know that you control it, you can act upon it, and you own it. Right? And if you do this and you follow this idea of unifying your data set in one place, again, with or without Tealium as a consolidated data layer, you'll be in a much better place to make decisions about how you govern said data. Now, over here at Tealium, we want to be the common data source for thousands of experience applications. We want to build real-time and neutral universal data hub for ingesting and combining this data. And we want to act as a data supply chain for our customers feeding all of their customer experience data sets to all of their applications. And what's interesting about that is we've consolidated that data layer. We can provide some very usable tools that help you deal with things like the right to be forgotten. If we've centralized your customer data set in a first-party manner, right, which is the most sensitive data set, and the customer has told you, as I've already shown you, we've got tools to make that very easy, I want in or I want out, we can tell as a data supply down to all of the vendors that you work with, all 20 plus, that this user wants to be in or out, right? We, as a data supply chain and as a data hub, can enable right to be forgotten very easily. Now, we've developed data governance at a core in Tealium, starting with the way that we collect data in terms of client-side tag management, building in these privacy widgets and explicit opt-in. We are do not track and global opt-out compliant out of the box. And of course, we've got a variety of tools that enable you to do auditing of your own data layer through our tools called SiteScan, Verify, and Tag Management. Of course, if we do any processing for you, because Tealium does act as a universal data hub processing user data in the cloud, we have a global processing footprint with geo-latent-based routing. And what this essentially means is we determine where the user is and store the data in the region that's relevant for the user. So if somebody's in Germany, the data stays in Germany. That's really critical when you start to think about some of these new EU regulations that are coming out, right? Making sure that we're in compliant with local laws. Of course, we're always concerned with people getting into our system, so we've built in multi-factor authentication, intrusion detection, and a very, very robust roles and permissioning system, not only so that we can protect your data from nefarious bad players, but of course, that you, as a technology team, right, you can provide the concepts of least access. And finally, from a storage perspective, hopefully you're seeing here, this is our data flow for you. We are doing that regionalized data storage. If we need to do things like private clouds for really sensitive data sets, we can absolutely do that. And of course, we have built into the tool the concept of purge rules. This is right to be forgotten. If you tell us that we need to forget about somebody, we'll make sure that we purge them out of the system. But of course, before we do that, we'll communicate out to your entire ecosystem and make sure that they purge that same user out of the system. That is your proof of burden, the proof of burden for your sort of legal background. With that, I turn it over to Malti to maybe talk a little bit about some of the things that we're doing on a business compliance perspective over here at Tealium.
Absolutely. Thanks, Chris. So one of the things that we always keep in mind is that, that our customers depend on us to make sure that their personal data is being protected, not only our users, but also their customers as well. And so we try to keep on top of what's happening globally in terms of rules and regulations. And we use those as a starting point for how we build our technology itself. We ourselves are getting ready to become Privacy Shield certified, and we've also, happily entered into standard contractual clauses with our customers who are in the EU. We are always and constantly looking at our best practices and implementing those into our policies and procedures. And because we're really, as an organization, we're taking privacy and security at a premium, and not only in terms of what we're building into our products, but how we're treating our customers' data as well.
Thank you, Malti. And thank you, everybody, for joining us here today. I hope you found it valuable. As I mentioned earlier, we will be posting all of our slides and the webinar recording. And if you have any questions, feel free to reach out to myself or Malti. We'd love to talk to you a little bit about how Tealium can help. Thank you.